You present in your papers about a dozen instances of prior use of cocky. Bite me cocky, a little bit cocky, cocky cowboy, cocky balls boa, cocky cowboys, cocky swats, cocky a stepbrother romance, cocky a cowboy stepbrother romance, and so on. Mr. Rubin tries to interject. No, you're out of the case, the court says. It is not clear the defendants used the word cocky in any way that makes it an indication of source. It is more a description of the nature of the contents. Her cocky firefighters, her cocky doctors. I hold that defendant is not using the word cocky in a mark. All right, so we have a really good one for you next, guys. This is going to take a moment to get through all of this, but I think you're going to have a good time with this. There is something going on in the world of cheap romance novels, as the judge calls it. These are the judge's words. I'm not characterizing because I don't know. But this matter came before the court on May 25th upon plaintiff's applications for a temporary restraining order and preliminary injunction. We are talking about a trademark on the word cocky. Which I don't know how I'm going to get through this without laughing every single time I have to say that word. But the author, who is Faleena Hopkins of Hop Hop Productions, has sued these three people, and this is very important, Kevin Nipper, Tara Crescent, and Jennifer Watson. These are three different people who have three different roles in the case, so that's why I'm trying to point that out now. And they are being sued for trademark infringement of the word cocky. Specifically, this scripted, sort of brushed expression of the mark. The judge held a hearing on Friday, June 1st, and one of the parties must have requested the expedited, seriously expedited transcript of this, because we've already got the transcript. And I wanted to go over it. It is 46 pages, but I read it, so I think we should be able to cover it pretty quickly. There are some M. Night Shyamalan twists in here that I think you're going to really enjoy. So this was held on Friday, June 1st at 11:30 a.m. You don't normally get this without spending several $100s on the transcript. Each one of these pages could easily be $5 to $10, depending upon the transcriptionist and the expedited fee. So kudos to whoever spent several $100s or somehow avoided spending several $100s on getting this so quickly. The court first goes over jurisdictional issues. Mr. Nipper has filed a trademark petition to cancel the cocky trademark, and that somehow gives plaintiff jurisdiction over Mr. Nipper, and the judge very quickly rules no, that does not. There's some stuff about who's been served and who's not been served, but the parties are all present, and since the parties are present and their attorneys are present, even if the parties are not, they're all represented. The judge and them, they quickly take care of that, and everyone continues with the hearing. They end up choosing to waive service in some cases. A waiver of service gives the receiving party, the defendant usually, about 60 to 90 days. I think it used to be 60, it might be 90 days now, if they waive service, rather than the 21 days that are required if they're served by hand. Plaintiff's attorney says that they were forced to file this order to show cause for the temporary restraining order for three different reasons. The first is that Ms. Crescent has published 2 books that are infringing on our client's trademark, cocky, that was duly filed with the USPTO. I have color examples of that. It is pretty difficult to tell from the black and white version of the document. I also have a board that puts the 4 different books, 2 by my client and 2 by Ms. Crescent, all together so you can see it is an infringement of my client's trademarks. The second is that the trademark registration is part of the complaint, and Ms. Nipper filed what we believe is an erroneous petition to cancel those trademarks. The judge quickly deals with Mr. Nipper and throws Mr. Nipper out of the case, which is good. So Mr. Nipper is out of the case. As to Miss Watson, at the time there was a secret, and I don't use that in terms of my own wording, but in terms of what was put out by Miss Watson, There was a secret movement called Cocktails, which we believe also infringed on our client's trademark. Ms. Watson, as a publicist, we have learned for Cocktails, has engaged other people and has requested that they infringe. So she's used your trademark, the court asks? Yes. Well, there is an issue of whether or not she used our trademarks once we were able to talk to the attorneys. I don't want to misrepresent it in the sense that she is not the owner of Cocktails. She is now, according to her attorney in declaration, only the publicist. However, as the publicist, she has clearly requested or promoted the idea of infringing on our trademark by telling people to write books with cocky in the title. After registration? After registration, Your Honor. So she is in the case. She is in the case. May I respond? Yes. Ms. Watson has nothing to do with the authorship, production, or distribution. She did not request anything of anyone, and there is no evidence in the record that suggests she requested anyone to write for the book. The court says, as a publicist, she has responsibility not to infringe. If this is a protectable mark, she infringed on it. She simply would respond and reach out to the media who want to write about publication of the book. The court says she stays in the case. The plaintiff's attorney says that the original impetus for the order to show cause is seeking a declaratory judgment. We want a declaratory judgment from the court stating that the trademarks are valid and that our client has a right to them. As a matter of what? Summary judgment? Yes, summary judgment. You're too early. You're here on a TRO or PI, temporary restraining order, or preliminary injunction. At least on the PI, Your Honor, we would like to enjoin Ms. Crescent from continuing to publish her books using our trademark. Start with the basic steps. She is a defendant, the court says. Either she's real or a pseudonym, and they make her reveal her pseudonym. And it's not here, but I won't go over that any further either. The judge says he can order things, and they agree, so they agree to the pseudonym thing. Your Honor, in terms of Ms. Crescent, if I may, I don't know if the court likes to use these types of exhibits or displays, but I have set up an exhibit that clearly shows, and I can hand this up to the court, shows 4 book covers. 2 are by Ms. Crescent, Cocky Doctors and Cocky Firefighters. The other 2 are by my client. My client has 19 books in this series already. Have defendants seen these pictures? Asked the court. They are part of the complaint, but not in color. The one I have I can hand to defendants in color. Mark it as Exhibit 1 and hand it up. 4 photographs, call them 1, 2, 3, and 4. Tell us which is which. Your Honor, number 1 would be Cocky Roomy, authored by Miss Hopkins. Number 2 would be Cocky Firefighters by Miss Crescent. 3 is Cocky Doctors, authored by Miss Crescent. 4 would be Cocky Mother's Day, a book authored by Ms. Hopkins. So these are some of the examples of the books that we're talking about. See if there are any more examples in here. This is apparently Mr. Nupper, who is trying to have it canceled. This is evidence of some kind of cocky collective trying to start a cocky series or something in protest. These are people who are, I think, also protesting. And I think we can go back to this. Good on you if you like those things. It's not my taste. Cocky Roomy was the first in the series. Cocky Mother's Day was the last in the series so far of 19 books. These are all by defendant. 2 are by my client, he says. The reason I lumped them together is so you can see. Cocky Trademark, the stylized one, to my understanding, was used a little bit later in the series in terms of the style, the way it was written, but the format of the Cocky cover has been the same since the beginning. There has always been the word Cocky above the other word in the center in large, bold type. You have also registered the word Cocky as a series of downloadable ebooks. That's correct. So the court says, how can you trademark the word cocky? Your Honor, there are a few ways. The first thing is that in a series, the case law is very clear on this. You can trademark words like cocky without issue. Second is when you say the word cocky, you don't necessarily think of anything that is relatable to the book except the book itself. So it identifies the book. It is definitely a source identifier in terms of what you think about. Ms. Hopkins has 600,000 books sold so far, so this is a community that is all well-versed in her books and the book covers and this trademark even before she filed it. Do defendants argue that there is any relationship between the title, cocky, and the contents of the book? Plaintiff's attorney answers, I don't believe they do, Your Honor, but that would be erroneous. Cocky is a term used for this book as a source identifier for the series. That's the key. The key is that this is a series. We are looking to protect it as a series in the same way that Star Wars would be protected. The court says if you can protect one, you can protect the series. If you can't protect one, the fact that it may be a series doesn't help you. Your Honor, I'm not sure if I agree. The court says repetitive use. I'm not sure if I agree with that, says the attorney. It provides a pointing to the source. If I want to buy another book in that series and I see the word cocky, I understand that I'm now buying a book in that series. The same way if I was buying a book in the Twilight series, which is copyrighted. The court says, in other words, you want to be able to prove that there is a secondary meaning here because of the use of the series. And the attorney answers very carefully here. If the court wanted me to do that, I think I could do that, but I don't think this requires secondary use. I think the case law clearly shows that it doesn't. I don't think cocky is, at least it is suggestive. So what he's saying here is very, very important. This is touching on the different levels of trademark protection. If cocky is merely descriptive, it is descriptive of the contents of the cheap romance novels. If it just simply describes, hot dog stand describing a hot dog stand, that's not trademarkable because it is descriptive. However, if somehow your use of a merely descriptive trademark achieves recognition in the market, and people know that that hot dog stand means your hot dog stand, you have some kind of trademark protection. Bare minimum of trademark protection, but you have a little bit. So if cocky is descriptive, it has either no or next to no trademark protection, and its protection would only come into play if there is secondary use, if there is secondary meaning in the marketplace, and that's what they're talking about here. And the attorney says, well, we don't have to go there because we don't think we have a descriptive mark. We think we have the next level of trademark protection, a suggestive mark. That cocky is suggestive of the material, but not descriptive. Power computing, Western Digital, International Business Machines. It's not descriptive exactly of what they're selling, but it is suggestive of what they're selling. So a suggestive mark has a little bit more protection. For example, Western Digital doesn't have a trademark on Western or digital. It's only on those two words in connection with the selling of their computer products that they have been selling and filed a trademark on. So if cocky is suggestive, then we don't need to go into the secondary meaning. So the judge says, do you think it is suggestive of male prowess? The plaintiff's attorney responds, I think it is suggestive of if you walk through a few steps, you would get to a romance novel. That is what we are protecting here, the use of the word cocky on the cover of a romance novel. The court, you said it is not descriptive of anything or suggestive of anything. It seems to me to be at least suggestive of male prowess in a romantic situation. I would say at least we are in the suggestive category, which is worthy of trademark protection. The court says all of these books have to do with the prowess of males. The plaintiff's attorney, yes, but more important, all of these books have to do with the Cocker family. The first 6 books were about the original 6 brothers. The next set of books were about their children. So we follow the Cocker family. They are known as cocky. That's why cocky is used in the titles. Also, the defense argues that Cocker is the name of the series. That is not the name of the series. The court, that doesn't prove anything. Anything else you want me to say on the validity of the trademark? Not at this point, Your Honor. I just want to respond to whatever the defense says. So then we come over to the defense. Mr. Ruber attempts to speak on behalf of the defendants, but he represents Mr. Nupper, who is out of the case, so he defers to Ms. Lackman. She says, a couple of points. One is with respect to the protectability of the mark and how strong it is. The fact is we have this on the record. This is a commonly used term. They are by romance writers. This is not something out of thin air. This is not Harry Potter or something like that. The term cocky has been used in connection with a series well prior to the time Ms. Hopkins used it. The court says it started out with Cocker Brothers. Ms. Lackman says, exactly. If you look at the books that were marked, you can see certain indicators of source here. I see Cocker Brothers being used consistently, independently. I also see Ms. Hopkins' name. The term cocky is not used as an indicator of source, nor should it be. It describes the books. It describes the contents of the books, as do the books written by my client, who clearly labels her books with her name on top. Everyone knows that they are not Ms. Hopkins' books, and who actually started using the terminology for books prior to Ms. Hopkins. The question of validity, I think, is something that will be heavily fought, perhaps with a petition to cancel. But in terms of the strength, this is not the type of thing that can be used to censor other authors, especially those who have come before. The court says it is clearly being used as a source, isn't it? Indicating a source for a series of books. The defense attorney says, as this shows, this does not show an indicator of source. If I look at this, I would not say cocky is a trademark. I would say cocky is part of the title of this series of books. In fact, the title changes in every term. The title of the book is not Mother's Day by Cocky or Mother's Day originated by Cocky. The title is Cocky Mother's Day or Cocky Roomy. The source is Faleena Hopkins, and it appears to be 2 books in the series Cocker Brothers, which was consistently used, and we don't challenge that. So out of anything on these covers that shows an indication of source for Ms. Hopkins, it is her name, it is the term Cocker Brothers, and perhaps the series. For Ms. Crescent, it is her name, and there are a series of titles. Trademarks are entitled to be used. The court interrupts. You are arguing, looking at Exhibits 1 and 4, that cocky roomy is an adjective. Correct. And cocky Mother's Day? Cocky describes the contents of the book. It is an adjective. It is descriptive of that book. The court says, I don't see that. Let's talk about Exhibit 4, Cocky Mother's Day. There is no connection between cocky and Mother's Day. Ms. Lackman, there may very well be. I haven't read the book, Your Honor, but there is an impression or suggestion here that based on that image that is shown, based on the genre, Cocky Mother's Day refers to some event on Mother's Day or relating to Mother's Day that involves some male prowess. When one goes to the store or on Amazon and says, I'd like to buy a romance novel, they look for, I want to buy a book by Faleena Hopkins. I want to buy a book in the Cocker series. When they see Cocky Mother's Day, that is a title of the book. Cocky Roomy is a title of the book. The court, Cocky Mother's Day is clearly not an adjective. Ms. Lackman, it is an adjective of the book. The court, it is nonsensical. Ms. Lackman, it describes the contents of the book. This is not to the average person that would identify the source any more than Mother's Day. Mother's Day is not an adjective. It is not an indicator of source either. Book titles are inherently, as a matter of law, not protectable unless you can show the court needs a recess. To wrap up the point of Your Honor's question, titles have something to do with the content of the book, and that is what matters here. What is the relationship? Exhibit 1 is about a cocky roomie. Exhibit 4 has something to do with there being a Mother's Day plot or something along those lines, and it involves the assertion of male prowess. I can see in number 1 that it shows a male stripped to his waist, a tattoo on his arm, defined biceps, defined abdominal muscles, with a certain look of haughtiness. It seems to me that the title here, Cocky Roomie, is a description of the type of roommate this person is or this person has. As to Exhibit 4, Cocky Mother's Day, the depiction is of a young man with an open-collar sports shirt, various items of what appear to be a watch and cosmetic jewelry on his wrist, a pose that shows a certain haughtiness. What this has to do with Cocky Mother's Day is anybody's guess. So the cocky, I think, relates to the picture and is descriptive of the picture, but it may not have any meaning in relationship to Mother's Day. The plaintiff's attorney responds, it may or may not, Your Honor. I assume that the reader would want to buy the book to find out. The real question here is this a valid indicator of source? That also depends on a couple of other points, one of which is she wasn't the prior user of this series of marks. All of these books, or a significant majority of the books that are described that Ms. Hopkins wrote, were not sold or used under the term cocky. Many people have used this term before. In fact, my client's books predate Ms. Hopkins' first use of the term. I think this is a misstatement here. This is not plaintiff's attorney. This says plaintiff's attorney here, but this is actually being said by Ms. Lackman, the defense attorney. because her clients would be the ones who are being referred to. My client's books predate Ms. Hopkins' first use of the term. My client is not claiming rights in the term cocky because, as shown in Exhibits 2 and 3, that is not a trademark. It is designed to entice the buyer into buying the book and reading the stories, and it sends a message as to what the stories may be about, that they may involve some assertion of male prowess or otherwise. So this is not a question of branding. You present in your papers about a dozen instances of prior use of cocky. Bite me cocky, a little bit cocky, cocky cowboy, cocky balls boa, cocky cowboys, cocky swats, cocky a stepbrother romance, cocky a cowboy stepbrother romance, and so on. Mr. Rubin tries to interject. No, you're out of the case, the court says. I understand, Your Honor, but I penned the brief and there may be an error that my client alerted me to this morning. Specifically, it is the first one, Bite Me Cocky, published in 2012. He has learned that the title may have been changed as a result of the Cockygate sort of disputes. It may have been originally published as Bite Me, not Bite Me Cocky. I just wanted to point that out. Originally Bite Me, then it became Bite Me Cocky, says the court. Yes, Your Honor, that was our understanding. What's the explanation? As a protest, effectively, he says, this is our best guess. In response to the protest, he added the word cocky. In response to the Cockygate registrations, yes, we believe the author added the word cocky as a protest. This is pure supposition on our part, Your Honor. We have only been doing this for 48 hours. The plaintiff's attorney responds, Your Honor, since this started the whole Cockygate thing, I know about that, but it is really irrelevant, says the court. The use of the word cocky and the infringement on my client's trademarks, if the court finds them to be valid. The court says, let's stick to the point. The defense attorney, Your Honor, we are not aware that anything else on this list is incorrect. As Your Honor will see, these dates well predate the claimed date of first use, which we also submit is actually fraudulent, but that is a separate question. What is the nature of these books? The plaintiff's attorney, the nature of the books, Your Honor, follows the family called the Cocker family through their multiple generations of love lives and family life. 5 brothers? No, 6. The original series is 6 brothers, 6 books. Each one is dedicated to a different brother. The next is about their children. Cocky Rumi is one of the brothers. Cocky Mother's Day is one of the holiday books about the characters. Cocky Mother's Day, Cocky Christmas, things like that. Again, I think you're right, Your Honor, in your assessment that there is no way to assume that cocky would mean what it would typically mean in that title. By the way, to address Ms. Lackman's point about prior titles, I would point out that none of them are a series. My client's is a series, which according to trademark law is very different than a one-off. None of the one-offs she speaks about has applied secondary meaning to give them trademark rights, and none of those individuals are here to contest what we are trying to do. So it appears that right now the plaintiff's attorney is trying to say that the series cocky whatever has achieved secondary meaning. And when people look for a cocky cowboy whatever book, they expect it to come from Faleena Hopkins, I think is what he's trying to say. Ms. Lackman responds, Your Honor, that is not correct. There was no series. Putting aside the minimal relevance of that, it was not correct that there is no series prior to what Ms. Hopkins claimed is her series. Cocky Cage Fighter series came out in 2015, she says. Case Fighter? No, Cage Fighter. The plaintiff responds, There are numerous examples and I can give them to you now. I believe the cites are in my reply. Cherished Romance has been afforded a trademark. Silhouette Romance has been afforded a trademark. The word class in terms of a magazine has been afforded a trademark. The court says there may be a different standard in the patent law office than there is in the court. The plaintiff's attorney, okay, in that case, Your Honor, Cocky Cage Fighter, we have no objection to that. You can use it in the sense as an adjective in a long sentence. It is not used in the way Ms. Crescent uses it as a way to confuse the public and direct readers to her series instead of our series. Cocky Rumi, and what you said before. You said one of them was descriptive. You admitted that one of them was descriptive. No, Your Honor, I never admitted that any one was descriptive. I am saying that the book that Ms. Lackman is citing, Cocky Cage Fighter, has nothing to do with my client, that there is a descriptive use of the word cocky in the title. So this goes back and forth for a little while over whether or not the mark is being infringed because it's descriptive or suggestive or whatever. So the judge finally gets to looking at the law. There are 8 factors in the Polaroid case, which is a famous trademark case. They measure likelihood of confusion, and the judge goes through them. The first is the strength of the plaintiff's mark. It seems to me that at this stage of the litigation, that it is a weak mark at best, and the judge just determines that and goes on. The next factor is the similarity between the plaintiff's marks, and the judge finds that they are definitely similar. Cocky doctors, two male figures, etc. Cocky Collective is mentioned. There is a book called Cocktails, the Cocky Anthology, featuring a rooster or cock on the cover. The judge gets to look at that. What you are telling me from the judge is that if cocky is a valid trademark, then it's deliberate infringement. Deliberate parody, Your Honor. This is a deliberate parody, Your Honor, an attempt to protest. In fact, the forward points that out by one of the authors. The second factor in the Polaroid factors, the similarity of the plaintiff's and defendant's marks, the judge finds them to be similar. The third factor is their competitive proximity, the judge finds that they are competitive. The fourth factor is whether plaintiff will bridge the gap and offer a product like defendants, and the judge agrees that the plaintiff and defendant are offering similar products. Fifth is actual confusion, and we're looking at either one or three examples of actual confusion. The plaintiff's attorney points to a couple reports from the marketplace where people said that they thought that the other book that they bought from a different author was part of Faleena Hopkins' series, and it was not. The judge disagrees that this is actual confusion. So the court can't resolve some of the Polaroid factors on the preliminary injunction, namely the defendant's good faith, the quality of the products. To sum up, the most important factor we have gone through here is the strength of the plaintiff's mark. It seems to me at this point of the record, and given the way that these titles look to be more adjectives than indications of source, that we have a weak mark. It is not clear that defendants used the word cocky in any way that makes it an indication of source. It is more a description of the nature of the contents. Her cocky firefighters, her cocky doctors. I hold that defendant is not using the word cocky in a mark. Defendant is not using the word cocky in a mark. Although there could be likelihood of confusion, all other factors being equal, that there is some kind of infringement at this point, I don't think there's a similarity. Third is the competitive proximity of their products. They are clearly proximate. The fourth is the likelihood that the plaintiff will bridge the gap. The judge continues to go over the Polaroid factors. And then the judge turns to the irreparable harm. Plaintiff will suffer irreparable harm if others occupy the field. Although sales data can be obtained and damages can be proved, it is also a damage to goodwill to be involved with a trademark that can't be proved. So there is clearly irreparable harm that would be suffered by the plaintiff in the absence of restraint. However, it seems to me the defendant, who is on the market with her romance novels, would, if restrained, also suffer damage that would be irreparable. If a book is taken off the market, it can't be sold. Books of this nature have to do with timeliness as well, so I can't say that there is any balance here. If there is, it is likely to tip in defendant's favor because a good portion of the injury by the plaintiff would be compensable in damages and captured profits. So that factor is in favor of the defendant. Whether an injunction is in the public interest, given the way these trademarks are used, I don't think there is much of a public interest in them. Here, plaintiff can't demonstrate that its trademark merits protection, nor, in my opinion, the defendant's use of a similar mark is likely to cause consumer confusion. Those are the 8 factors that we just talked about. Accordingly, the motion for a TRO and for a preliminary injunction is denied. That doesn't mean the case is over. It means that we go into the next stage of discovery. I don't know if you're prepared for that, and the court talks further about waiving service, so they'll have time to respond, and September 7th is discussed as a date to complete discovery. So we may not hear anything more in this case for some time. But the judge blew me away by saying that the defendants are not even using cocky as a trademark, and therefore they cannot be infringing for the purposes of this temporary restraining order / preliminary injunction, because they are not even using cocky as a source identifying trademark, which is the purpose of it. It has to identify the source. Are they trying to identify the source of their authorship as cocky? No. Their source identifiers are their name and maybe some styling on their title or something, but mostly their name. So if you want something from the cocky series, yeah, maybe they can trademark, maybe the plaintiff can trademark the cocky series, but no one is saying that, you know, Cocky Cowboy was from the cocky series by Faleena Hopkins. So, interesting outcome that the use of the adjective or descriptor cocky in the title of the book does not make it a source identifying trademark, and therefore you cannot trademark individual titles. So far, we'll see what the rest of the case has to show for us. What do you think of that? Hello, Yessa. Can Yessa come up? You're a good girl. You're a good girl. Yes, you are. You are. That's my good girl. Yes. That's my good girl. I don't hurt your leg. Good girl. Thank you very much to all of our Patreon supporters. You can go to patreon.com/ljfrench to learn how you too can become a monthly Patreon supporter. Our $500 supporter for the month of June is again Kareem Harper. Thank you very much, Kareem, for your support. At this point, I'm calling you our benefactor. Thank you very much to our $50 plus supporters: Jonathan Doe, DJ Gilcrease, John Steele, Gavin Barnard, Evie, Andy, Kyle Mudrock, Sean McNamara, Vera Montaigne, Johnny Chanderson, Michael Pierce, and William Gonzalez. Takes a whole breath to say that. And thank you very much to the 216 $5 plus supporters. I think I saw somebody switch their pledge last night. Thank you very much to all of you. You're all on the LED panel behind me, and when I do the VODs, I try to make graphics to scroll on the screen. I'm working on motion graphics, but After Effects is hard. It takes time. And we're 3 VODs behind right now. I have 3 videos that need to get done. Alright, so that is our show, everyone. Thank you very much for joining me. I'm going to let you all go, and I'll see you again in about 11 hours for the Devolver Digital reveal. Alright, we're out in 18 seconds, everybody. Have a good one.